Impeaching judges. Is this something that our Constitution allows for? Don't we have an appeal process? What's going on here? Why is this something that we're suddenly now hearing about? What is the history behind the impeachment process? Welcome to Into the Desert, exploring the wilderness of ideas. Don't forget to hit that like and subscribe button and put your comments below. What do you think about impeaching judges? We do read your comments and we look forward to what you say, but remember, keep it respectful. Now, I came across an article recently that says that Trump is now impeaching more judges, and there's all of this talk about our judicial system and Trump's attacking everybody, and it just seems like a new thing, something that we've never seen before, and I'm just kind of wondering, is this something we should be expecting? Is this something we should have been doing for a long time now? I mean, what is the history behind this conversation, and what's the difference between impeachment and appealing a decision?
Well, what you see now is touching on a very deeper problem within our system, and it's the fact that we don't have a clear source of authority. We actually have separation of powers, which we all learned in school. And separation of powers means that the ultimate say of the Constitution belongs to the courts, the Congress, and the president. It's not one person or one group that gets to have a final say. They all have to get to have a final say. And so everything's fine when everyone's in agreement, but what happens when they differ? And that's exactly what's going on now. What's sparking the problem is this thing called a nationwide injunction. And that really is new. We never had nationwide injunctions until around the 1960s when we began to occasionally have a nationwide injunction. And the reason that's at all at odds is because you have a judge, a district judge, and the district judge is ruling on a case. Now, normally they would rule on the case, and the case would go up to an appeals court, and then would go up to the Supreme Court for a final decision. But what's happening is district judges, who in theory only rule within a given district, issue what's called a nationwide injunction. So they stop a whole process nationwide. So can a district judge who's responsible for a particular district actually make a nationwide decision? Like I said, we never had this question until the 1960s. And then when we had it, it didn't happen very often. It was a rare exception, and one of those things that nobody bothered to, they may get upset about it, but what do, right? So it just sort of went along. Well, that was fine, and the number of nationwide injunctions began to increase. Even when you start the first part of the 21st century with Bush, they were still very few. Under the Bush administration, we had 6. Then you moved to the Obama administration, and during Obama's 8 years, they doubled to 12. And then you had Trump come in, and suddenly you had 64. Well, those dropped back down to 14 under Biden, but now here we are again with the Trump administration, and they've jumped up to 30. And so people are beginning to question seriously whether a nationwide injunction is legitimate. And you think about it, if this was one of those things that happened on both sides, well, all you have to do is find a judge somewhere in the country that would rule the way you would think, you would want them to. You go put your case before that judge, they issue a nationwide injunction, and that stops. So, how do you deal with that? And given the appeals process is so long, a lot of these delays can be very significant. That's on a recent nationwide injunction. Judge ordered the Trump administration to pay out a large sum of money, and it went to the Supreme Court. The Supreme Court upheld it, but in the dissent, one of the judges mentioned, well, how can a district judge make that kind of decision for the nation? And you can't reverse that, because once the money goes out, you're never going to get it back. So that's where a lot of this confirmation or consternation is coming in, is how do you do that? How do you have a district court judge actually make a decision for the nation? And again, this is a gray area, because the courts don't really have the ultimate say on the what the Constitution said. They think they do, and they declared for themselves in Marbury versus Madison that they have that authority, but that's not the Constitution. That's the court claiming an authority for itself. And again, following Marbury versus Madison, they didn't really use that power, because when you have a vague gray power, if you push it too much, people will push back. But if you push just a little bit, you can oftentimes get away with it. And so with Marbury versus Madison, the court declared their power to overturn constitutional law. Okay, they didn't use that power again until the infamous Dred Scott decision, which we have a video on. And in the infamous Dred Scott decision, they declared the Missouri Compromise unconstitutional. And so if they rarely use the power, no one really questions it. You fast forward a couple hundred years, and now everyone takes that power for granted. But that's not what the framers thought when they put together. In Federalist 81, Hamilton says the courts are the weakest branch, and there's nothing to fear from the courts usurping power, because the Congress has the power of impeachment. So the Federalist Papers actually lay out that if the courts get out of control, Congress can always impeach them. Now, they also have some other measures they can do. For one thing, they can just declare certain issues are non-judiciable, although that's an issue with one of the injunctions, because the law already says this is a non-judiciable decision. But then the courts are asking as well, does this actually fall into the non-judicial part? And let's have a judicial hearing to see if it's judiciable. So a lot of this gets very strange, gets really deep into the legalese. But ultimately, it comes down to separation of powers. Is the president the sole authority for the Constitution? No. Is the Congress? No. Is the courts? No.
So this has been going on for a really long time. Well, at least until the 60s. So isn't there legal precedence now? I mean, that's kind of the one thing we always hear about is, well, it's legal precedence and we have a precedent and now that precedent is set, so we're stuck with it. And so it seems kind of like, after the fact, and now we're stuck with the fact that we've given the courts this power. Can we really go back and undo it all and say, oops, sorry, we didn't catch this 40 years ago, 50 years ago. Now we want to stop it.
Yeah, well, there's some of that, but there's actually two things. Well, one, stare decisis is not absolute. If it was absolute, we would still have Plessy versus Ferguson, but the court does come back and overturn things. We did a second infamous decision. We had Plessy versus Ferguson, which was effectively, although not explicitly overturned by Brown versus Board of Education. Then we had Karamatsu, which was the internment camp decision. It was the third infamous decision of our video series. And that was effectively overturned just recently, although it had been long ago rejected. The Supreme Court just sort of formally put the stamp on it as a bad decision. So when you have bad decisions, and we've got another one coming up, Buck versus Bell, which is another horrible decision, and you do not want those around. So there are specific guidelines for when you overturn a decision, when you don't overturn a decision. One of the problems is that that's the court telling you what the court can do. The problem is you still have the House and the Senate and the executive branch with the president. They're also equal partners. So the court has declared itself, yes, we're all equal partners, but we're more equal than everybody else. And that doesn't really go down well with the other branches.
So it sounds like, with everything that's going on, it's really not impeaching a judge for a bad decision or impeaching a judge because they're corrupt or they're taking bribes or they're doing something wrong. We want to impeach judges because, or it sounds like Trump is trying to impeach judges because that they're doing something that he doesn't want them to do, which doesn't, to me, seem like a really solid legal basis to making a decision. If the problem is that judges are putting on nationwide injunctions and judges are taking on more power than they need to, it's not an individual judge that's causing the problem. It is more of an epidemic with the system. And it sounds like the legislature and the executive branch need to come together and put boundaries around what the courts can and cannot do.
Well, yeah, there are two issues here. One, these are by definition disputes. So both sides are going to paint the other side in the least desirable terms. So, both sides will declare the other side is violating the law and they are upholding the law. So that's just the nature of a dispute. And so how do you tell? In many respects, yeah, it is going to be. That's the danger you get into if impeaching judges for something beyond corruption or something. You're going to get into you don't like the decision. Now, you may not like the decision because you wanted it to go a different way, or you may not like the decision because you think there are really sound legal basis for that. But either way, you're impeaching a judge because you don't like the decision. And even though Hamilton said that was very appropriate for the legislature to do, it is still a dangerous road to trample, because we don't want judges making decisions in fear of being impeached. We want them to make decisions based on sound legal principles. The problem is inherent. What is a sound legal principle where everything is in a state of flux like we are now? I mean, yeah, if they had gone after the first judge with a nationwide injunction and says, no, you can't do that, just go ahead and make the decision, pass it up to the appellate court, let the appellate court decide, pass it up to the Supreme Court, and then let the Supreme Court decide whether it's a valid decision and precedent that they want to maintain, or if there's some reason that decision and precedent needs to be overturned. That's the job of the Supreme Court. But even there, you're getting, with the current court system, you're getting into problems. For example, there's a case just recently that out of Florida. The case was Littlejohn versus School Board of Leon County. And there you had a case where the parents explicitly told the school system they did not want their child to transition. And the school went behind the backs of the parents, hid it from them, and helped the child transition. And the parents then sued the school district because they are the parents. They have the ultimate responsibility, and it's not the job of the schools to go behind their backs and do what the school wants to do. Well, that's what's basically called black letter law. There's a lot of precedence that says that's the case. Sure, in certain circumstances, if the child's in danger, the state can step in, but they remove parental custody from the child, and they make it basically an adversarial system where the parents get to say, the people who want to support the rights of the child get a say, and the judge makes the decision. It's done in open court. This was done behind their backs. They had explicitly said to the school, do not do this. And the school explicitly hid it from them. Well, that's pretty clear in the legal world, at least it was, that the parents have the right, unless there's an actual injunction against them. The government doesn't have the right to hide things from the parents. Well, that went up to the court. The court ruled in favor of the school. It went up to the appeals court, and the appeals court has ruled in favor of the school, which is, you can kind of scratch your head and say, on what basis did they do that? Well, now it's going to go up to the Supreme Court, and the Supreme Court will make the actual decision. But it's not, until now, it hasn't been the job of the appeals court to overturn decisions. It's the job of the Supreme Court to do that. So that they're overturning what have been very clear precedents up until this time is a little strange. And again, you have the issue of, are they exceeding their authority? So, there are legitimate complaints on both sides, and ultimately this has to get itself worked out. Who does ultimately control the Constitution? Is it the courts? Is it the legislature? Is it the president? Well, actually, ultimately, it's the people. And if we insist on certain things, then we will get our way. If we just sort of ignore it and are apathetic about it and don't pay attention to what's actually going on, but spend most of our time just rooting for our side because we want our side to win, well, then it'll be handled outside of our hands as well.
Yeah. I think that's probably the biggest takeaway here is, as a nation, we need to have a say of where the division of power is. And right now, I feel like the power lies with the court. The court has the ultimate say on what we are allowed to do and what we're not allowed to do. And it's been making these decisions ever since I was a child, in the fact that, are we allowed to say the Pledge of Allegiance, or are we not allowed to say the Pledge of Allegiance? Are we allowed to have prayer in school, or are we not allowed to have prayer in school? Are we teaching evolutionaryism, or are we teaching creationism? These are cases that I learned about in school. These are cases that I learned about in my childhood that have shaped the way I think about our court system. But I think you're right. We are getting to a point where we have to determine, do the courts really have the ultimate say? Because if they do, then what's the point of the legislature and what's the point of the president? If the courts have the ultimate say, the rest of it becomes null and void, because no matter what the president says, the courts will determine whether he's right or not. Whatever the legislature does, the courts will say whether they can do it or not. And the legislature then becomes I'm going to write your check for your budget, and that's about it, which, we can see how effective they are at that. And the president's going to say, I want you to have this money and not have that money. And he has, whatever authority on that. And it really just means the court have all the say. And I don't really believe that that's what our founding fathers intended. And I don't know if that really works.
Well, that's one of the reasons that, that you have these political battles over judges. You know what? No one used to care. Pretty much, judges, all they could do is rule on the law. They didn't write the law. They didn't enforce the law. They could only rule on the law. And so nobody cared about what the judges were. And when you had even a Supreme Court nomination, it was of little interest outside the legal community, who the president nominated and who became the new Supreme Court justice. That changed in the 80s because the judges had, since the 40s and 50s, been taking on an increasing role, one that determined policy more than it just rule on it. And you saw the backlash, and then in the 1980s, particularly with the nomination of Robert Bork, that was the first Supreme Court justice who was actually seriously challenged for political reasons. It's hard to imagine, but just a year before, you had Scalia nominated to the court, who was considered one of the most conservative judges. He was nominated to the court, and he went on the court with, I believe, a vote of 90 to nothing. It was in the high 90s, if nothing. There was no controversy about it. But when Bork came on the scene, then suddenly it was a controversy. And since then, justices have become more and more political in terms of who people nominate and who gets on the board. And you see this, in the decisions before the court as to people are now accusing them of playing politics as opposed to ruling on what the law is. So everything's a cause and effect. You push too hard in one area, you're going to reaction in another area. And, at the moment you see a flood of nationwide injunctions, and not surprisingly, it's getting a flood of pushback. And that's actually normal part of the system.
I agree it's a normal part of the system, but I also feel like we're addressing the wrong problem. We are putting the blame on the wrong side. And it's like someone's losing their arm and you're getting a Band-Aid to fix the problem. A Band-Aid's not going to fix a missing arm.
Well, particularly when you have judges making rulings on what was generally thought to be settled law. I mean, you could argue the Dobbs decision was challenging settled law, but it was a source of constant controversy from the time it was released all the way up until the time it was overturned. Hardly a year went by that there wasn't some major controversy about that. So that's not exactly what I would call settled law.
And I would say even since then it's not settled, because even today it is a huge controversy on both sides. So the courts haven't settled anything.
Well, yeah, but it settled down a lot, at least in terms of the last election. It wasn't the significant issue because you know what? It's gone to the states. Some states have abortion right up until birth. Other states have limited severely. It's state by state, and for the majority in most states are pretty happy with what they have done. So actually what Dobbs did, in my view, is it took a contentious issue which a minority opinion had been enforced by the court, it returned it to the states, and the states have all done what they wanted to do, and the minority has gotten out of it, and really the majority has gotten in charge. Because you know what, if you look at the actual polls and not the polls that are done to make my side look good or their side look bad, but if you look at the actual polls, you'll find that the extreme pro-life and the extreme pro-choice people are minorities. Most people are somewhere in the middle. They don't want abortion all the way up to the time of birth, but they don't want it banned totally. They're somewhere in the middle, and exactly where you set the limits determines how many people are with you or against you, or however you want to put it. That's the democratic process. It's messy. It's confusing. It's, yes, if you had a king, they could just set one side for all, and everybody would have to go by whatever the king said, but that's not democracy. Democracy is people get a vote. And if you haven't noticed, people have different opinions. So things that California think are just the way things should be done are not exactly the way things are done in Wyoming or in Utah or in a lot of other states. So, state by state, in some respects, it's the genius of the founding fathers, but it is messy, and it is at times confusing. And so we have this issue with the courts now. It's being battled out. Do the courts have a right to do nationwide injunctions? Are they the final say, as they declared themselves to be in Marbury versus Madison? What is the role of the legislature? What is the role of the president? They're supposedly co-equal partners in the Constitution, but how did that all work out? And we're seeing it play out in the political scenes right before our eyes.
We're going to end the conversation there. What do you think? Do you agree that it's more important in are they agreeing with you or disagreeing with you? Or do we need to look at the fundamental setup of our judicial system in comparison? What are your thoughts? Put them down in the comments. We'd love to hear from you. Thank you for watching Into the Desert. Don't forget to like and subscribe. We'll see you next week.